Good morning, everyone. We're just going to give it a few seconds for everyone to join in, but welcome to Serious LLCs Come to Florida, the Rise of the Protected Series. CLE course number is 9480. I will let all the participants know that to please submit their questions using the Q&A box. Just wanted to share some important information before we start. We just got back from our tax section fall meeting in Clearwater. Please note that the CLE is on the YouTube channel if you want to access it and just get a refresher of all the great material that was presented this past weekend. Reminder, we also have a CLE taking place on November 11th, Part 1, Mathematics of Estate and Tax Planning by Alan Gassman. We also have a boot camp primer before the ITC conference that's happening in June 21st. Allow me to present the speaker that we have today. It's Louis Conti. He's a partner in the Tampa office of Holland Knight. He advises domestic and international businesses on merger and acquisitions, business formations, governance, financing, and complex transactions. Mr. Conti served as chair of the Florida Bar LLC Act Drafting Committee. He's also the principal author of the Florida Limited Liability Partnership Act and as Florida's Uniform Law Commissioner. He is an adjunct professor at the University of Florida Levi College of Law and a frequent lecturer for the Florida Bar and ABA programs. He's a former chair of the Florida Tax Section. He's also a chair of the ABA LLC Partnership and Unincorporated Committee. Louis, thank you so much for presenting today. We really
Thank you,
appreciate it.
Audrey. I appreciate that kind introduction. Welcome, folks. I can't see you all, so I'm speaking into a screen. And if anybody has any issues, any questions, any problems hearing me, or feel free to, I don't know, can they speak up or only send messages? Probably only send messages, but I'm going to leave some time for questions at the end. And what I'd like to do is give you what I'll consider a brief overview as opposed to a technical overview of the legislation, because it's going to take longer than an hour to actually go through provisions in the legislation. Let me start by talking a little bit about series generally and why the drafting committee of the Florida Bar was formed to create, or to at least consider, series LLCs for Florida. When we started the process of putting together a task force from the tax section, the business law section, and the real property probate trust law section, those are the areas that seem to have the most interest, obviously, in why a series LLC might need to come to Florida. We already had, about when we started the process, 20 jurisdictions that had series legislation, 20 jurisdictions in the US that had some form of series. Delaware was the granddaddy founder of series LLCs, but series as a concept has been in the law for a very long time. There's been series partnerships, there's been series trusts, there's been series of corporate stock, series of investment funds. Series as a term has been used in the law for a long time. And the fact that there were other states using series LLC, the Uniform Law Commission, when they were considering creating a uniform Series Act. I was part of a study group back then. I was not in the Uniform Law Commission as a commissioner when this started, but I was an ABA advisor to the Uniform Law Commission's drafting committee. And we were taking samples from around the country of states that had series legislation and whether there were a lot of issues with series back then, because I'm going back now 8 years when this legislation started its genesis. And the problems were that judges were unfamiliar with it, lawyers were unfamiliar with series, and the states that had enacted series legislation were one-off states like Wyoming and Nevada, states that Wyoming's been let's face it, a trailblazer when it comes to legislation that's alternative legislation, that is something other than corporate law. And what I found was, or what the study committee found, was that there was such disparate treatment in the few states that had it back then that the Uniform Law Commission felt compelled to try to put together a better form of series legislation that hopefully would be adopted and provide uniformity to other jurisdictions, so that when you dealt with a series LLC, if it was from the Uniform Protected Series Act states, you would have other states with case law interpretations and a lot more, at least in my view, a lot more homogeneity in the context of what a series LLC is. So that's background. The reason we did it in Florida more than any other reason was because so many other state LLC series LLCs were operating in Florida. So we looked around and we said, okay, how do we advise clients when it comes to telling them you're going to be doing business with a series of a series LLC from another state? Let's call it Delaware. And Delaware law will apply to that, but what's going to happen if you have a problem in dealing with that entity from a business perspective, and you try to file a lawsuit in Florida asking a Florida judge to interpret Delaware series law and apply it in the context of your dispute? And there was no, obviously, there was no treatment or what I would call study of series in any way in Florida at the time. There were a few folks who did and used Delaware series. I was one of them who used series. If Florida clients wanted to form a series LLC, since we couldn't do it in Florida, we had to use one of the other states. Delaware, since it was the state with the oldest history of series and with the most case law, became the default state for forming a series if you wanted to use a series LLC. So what's happened since then? Over that period of time, the Uniform Law Commission undertook this study and then a 4-year drafting process. And during that 4-year drafting process, let me move to the next slide. It started actually initially based on the Uniform LLC Act of 2006, which is amended in 2013 and then again through 2024. And through those amendments, we refined at the Uniform Law Commission level this Uniform Protected Series Act, which finally was amended with final improvements July of 2024. And so the Florida Drafting Committee worked during that 4-year period from 2020 through 2024, monitoring the amendments that were being made in the Uniform Act. And we had some issues that we had to tweak for Florida law. That is, our LLC Act in Florida is a Uniform LLC Act based on the Uniform Law Commission's LLC Act. And when we adopted or started to work on the Series, Protected Series Act, we saw that there was some disconnect. And so we tried to bring some of the concepts that were already in our LLC Act and make sure they were held consistent as they would be interpreted in the Protected Series Act. So what you have over a 4-year period of drafting and 3 years in the legislature, took the 3rd year in the legislature before it got passed. It was passed last year. And we're very happy to have it finally coming, but it's not going to be effective until July 1 of 2026. So you can't do anything with them now in Florida. And the reason we have such a delayed effective date is because the Department of State did not get a lot of funding, and they had antiquated software and hardware, and they were in the process of changing over a lot of their hardware and software, and they needed more time to build in protected series LLC documents and forms and to train their folks. So that's why we have a July 1st effective date. So when you look at this next slide that's up now, the current legislation, and it's available now on the website for the Florida Bar's tax section. It should be available in the business law section. It was Senate Bill 316 and House Bill 403 that was ultimately enacted. We had great sponsors in Tallahassee, Senator Berman and House member persons Mullica. Both were lawyers and both were highly respected. One was a Democrat, one was a Republican, which was great. And so they managed to get this bill passed. There's a typo in that slide showing July 1, 2926 is wrong. It just delete the 9, it's 2026. So let's talk about how we came up and why you have a term called protected series instead of series. The reason we adopted at the Uniform Law Commission, and the reason the Florida Act Drafting Committee adopted protected series is to distinguish it from a plain series LLC. The reason we wanted to distinguish it is because there are so many uses of series already in existence. I mean, we have formed in Florida series entities like investment funds, mutual funds, cell funds, all kinds of what I would call big money users of the term series. There's also been used in Florida series corporate stock, series bonds, and series partnership interests. And so we were concerned that judges or lawyers might have some confusion as to why there was a difference with what the Florida LLC legislation was going to do if we just called it Florida's series LLC legislation. And because we wanted to make it clear we were adopting the Uniform Law Commission's protected series designation, we felt it important to keep that designation. So when you talk about series LLCs in Florida, you're always talking about protected series if it's going to be based on a Florida protected series LLC. In addition, I have a small note here on this slide that in addition to going through and adopting the Uniform Protected Series Act and modifying it slightly with what we'll call Florida flavors, we also had to make changes to the Chapter 7, Chapter 48 in connection with service of process. I'm not going to address the service of process changes, but they are going to be consistent with service of process, which we've moved out of the entity statutes and moved it into Chapter 48. And there'll be a reference in the entity statutes to look to Chapter 48 for service of process on an LLC, or in this case, a protected series LLC. Okay. I note the last point on this slide is that Delaware has 3 types of series. They have a series LLC, they have a protected series LLC, and they have a registered series LLC. Delaware is still the state with probably the most formed series LLCs in the country. However, in doing some research, I found that states like Iowa and Illinois, Nevada, Wyoming, all have thousands of series LLCs that have been formed already. Virginia, for example, a sister state that we look to a lot when we draft entity changes to our entity laws. Virginia adopted the Uniform Protected Series legislation, as did Tennessee and a number of other states. Of those states that have adopted the protected series construct, some of them have done the same thing we've done in Florida, which is add a little bit of local flavor based on existing law in the state and concepts in the state, which they wanted to make applicable in their protected series designations. So we're now starting to hopefully see not only uniformity in legislation, but also hopefully we're going to start seeing some opinions. There are very few opinions addressing series LLCs and particularly protected series LLCs because it's such a new concept. But there are cases. If you did a search for any kind of series LLC case law, you will pull up a fair number, but you won't see anything in Florida. And that's one of the reasons that this is not for everybody to run out and adopt for small businesses. I'll talk about that a little later. Let me move on to the concept. So what is a series, protected series LLC? So the concept is that the LLC that is formed in Florida as a protected series LLC, also called, we'll call it the mothership for my discussion purposes. That protected series LLC in Florida has the ability to create a series, one or more series, simply by filing, I'm not sure where that came from, but simply by filing a designation with the Secretary of State's office, designating a series that they want to create. The Department of State currently is working on their forms. Once they have completed their drafting and worked with the leadership of the department recently on the forms that they're going to need, we're going to probably have a follow-up, more detailed presentation about the process of forming the protected series LLC, the process of designating series within that protected series LLC, and the type of certificates one could obtain, not only for the mothership, but also for any series, protected series that are created within that mothership. And that all of those filings and certificates that will be available through the Secretary of State will be something we'll be talking about once they've completed their internal processes. So why do I want to make this fundamental point as the most important thing hopefully you'll take away from this? The protected series LLC itself is a separate legal entity, just like a regular LLC. Any protected series that are designated by that protected series LLC will not be a separate legal entity. And in some states, it's clear that they have entity status for series that are created within a series LLC in some states. Other states say, no, they're not a separate legal entity. But in all states that have adopted series legislation, including Florida, a protected series created by a protected series LLC is deemed a person for purposes of the UCC, which means that it can contract with third parties, it can hold its own assets, incur its own liabilities, sign contracts with third parties. It can be a debtor. It can make UCC filings. So it's treated and deemed to be as if it were a separate legal entity, even though it's not actually a separate legal entity. Why is that important? Well, the first reason it's important is because there is no case law, what I would call seriously addressing bankruptcy issues for series LLCs anywhere. We have had some case law dealing with the rights to file for bankruptcy. A series LLC certainly can file for bankruptcy, but the question is, can a series within a series LLC also file for bankruptcy separately, or are all of the series going to be dragged into the bankruptcy, or is the mothership also going to be dragged into bankruptcy? That is consistently one of the biggest issues that one has to be aware of and advise clients about. There's also some question as to how state court judges will treat protected series in Florida when it comes to the fact that they are a person and they can do all these things, and they are deemed to be treated as if they were a separate series, a separate LLC. Judges have never worked in Florida much with the concept of a foreign series. And so we have not seen any case law in Florida dealing with a foreign series with fundamental questions. And so we're going to have the judiciary learn about series, just as lawyers are going to have to learn about series once they become available in Florida. So I point that out because I want people to understand that protected series LLCs are not going to be for everybody and not going to be for small businesses. And we can talk more about that at the end. But if you have sophisticated businesses that want to utilize the series construct, it has a lot of value. And we'll get to that also as part of the sort of wrap up, as I'll call it. Okay, so how do you form it? You form your protected series LLC just like you would form a regular LLC, but you're going to want to use the term protected series when you file the articles of organization. And at the time you file the LLC, you also can designate protected series under that LLC. You don't have to do it right away. You can form the LLC. You can wait, decide when you're ready to form a protected series. You could then file a designation with the state. The interesting thing about these filings is they're not going to be expensive. They're not going to be difficult. But the name of the protected series LLC has to be in the name of any protected series that's created by that protected series LLC. The reason for that is because there has to be a mechanism for tracking the entity that is forming the various protected series. So if the name of your protected series LLC is ABC Protected Series LLC, the first series that gets designated is going to be ABC Protected Series 1 or Series 2 or Series 3 LLC. But the beginning of the name has to have all of the proper name of the Protected Series LLC under which any series is formed. There's also a mechanism that's important in the context of registered agent. The drafting committee felt it was really important to have one registered agent, not only for the protected series LLC itself, but for all protected series that were designated by that LLC. So one registered agent is obligated to serve as the registered agent, not only for the mothership, but also for every protected series that are created by that mothership. And that has to have the same official registered agent office. All notices and filings associated with either the series LLC or the protected series itself, they're not subsidiaries. Don't call them subsidiaries. They are separate persons, but they're not even subsidiaries. They are simply designated protected series. The annual reports are also important. Florida is going to require that any protected series LLC files an annual report for all of its series at the same time it files its annual report. They want to have a mechanism for tracking and maintaining status throughout the entity as well as the protected series that are created by the entity. We don't know what the filing fees are going to be, but it's not significant. The current process for foreign series, foreign meaning non-Florida series that come to do business in Florida, they have to qualify to transact business in Florida by filing with the Secretary of State. Once they get a certificate to conduct business in the state, they also are required to file annual reports. So that's being done now by the Secretary of State's office. And they don't, unfortunately, in the past, they have not done a count of the number of protected series or regular series LLCs that are doing business in Florida. They are going to implement, as part of the new software system, a way of tracking both protected series and foreign series that are doing business in Florida. So we'll have statistics on that available at some point after everything is effective. Let's talk about what constitutes ownership and management. So members of a protected series themselves at the LLC level are members of that LLC. In order to be a member of any protected series that are designated or formed by that mothership, they have to be first a member of the mothership, the LLC, in order to become an associated member of one or more of the protected series. So that association, and this term is really important because you'll see throughout the Act that members and managers are associated with a particular protected series, as are assets, as are liabilities, as are lines of business. Anything that the series, the protected series itself, is doing can be separate and apart from what the mothership is doing. It can be separate and apart from what the other protected series are doing within that LLC. It can have its own assets. It can have its own liabilities. It can have its own management. It can have its own financings. It can have its own borrowings. However it wants to be structured, it's the same thing you could do with a subsidiary of a holding company, but all within one entity, one legal entity. But it's really important that whoever's doing this in creating a protected series and associating the members, if it's going to be member managed, or if it's going to be manager managed, you have to associate the managers who are going to manage that series, the protected series. And you also have to have a document there has to be an operating agreement, a written document, as opposed to an oral. Right now, LLCs in Florida don't need written operating agreements. But for creating a protected series LLC that is going to designate protected series, it will be required to have a written operating agreement, because there has to be a mechanism for tracking which protected series are managed or owned or have an interest by a member associated with that series. And the reason for that is just the way business is conducted today by other series. So series in other states, in the series I've been involved with, what has happened is you have a tranche of investment options open to investors. These investors are typically sophisticated investment funds. And let's take an example of a real estate developer who is going to be developing 5 different types of real estate projects. They have one for residential housing, they have one for apartments, they have one for condos, they have one for office buildings, they have one for shopping centers, however many you can think of. That's how they're being used in real life. And so investment funds that want to invest millions or billions want their funds spread across different series of investment options. And so they will have some membership, associated membership in all of, let's use my example of, so let's say there are 6 series created for 6 different types of real estate investments that the money will flow through and the members associated with those different series will be associated by an operating agreement, which says, here's the money I'm putting in, here's what my rights are, here's the liabilities that may be associated with it, just as you would draft for a freestanding LLC. You can have, it doesn't have to be one operating agreement. You can have one operating agreement, but has references to separate series that have tie-ins to the main operating agreement, but have their own separate management, their own members associated with it, and their own activities and affairs. And you don't want to put all of that in one big operating agreement. You want to be able to have tied agreements, but have separate management agreements and operating agreements for the conduct of the separate protected series. One of the things that currently goes on with LLCs in Florida also is that we have a default rule which says that if you don't say anything about the management of an LLC, it is deemed under the statute to be member managed. That same rule is going to apply to any protected series that are formed in a protected series LLC. So that if you want it to be manager managed, you have to have a written statement saying that it's going to be manager managed. If it's going to be manager managed, but you have not designated any managers for that protected series that you're designating, then the mothership is deemed to be the manager of any protected series that are formed under it. So we had to have some default rules. That's sort of where we come out on the default rules. But it's in every, as I said, in every one I have ever seen, there are very precise governing documents for the big money stuff. What I've also seen now is some smaller businesses, someone who has a franchise operation and they have initially one store and they get a second store and then they get a third store and they form separate entities for each of their franchise operations locations. Right now, the advice is form a separate LLC for every one of those separate operations because that's clear and each entity stands on its own. There isn't any potential to drag them all together if you're being if you have a lawsuit by a creditor or whether it's a judgment creditor or just a creditor for financings. So you don't want to have small businesses with sketchy record keeping using protected series when it's so simple to just use separate LLCs. And That's not to bash the use of protected series. It's simply to say that I do not recommend protected series for Florida businesses that can easily and without a lot of cost form a separate LLC for each separate and distinct operation. It's, in my view, this is personal, this should only be for what I will call entities that are sophisticated with outside accountants who know what they're doing and can maintain the adequate books and records we're going to get to, and also deal with the association and dissociation of various members who have been associated with the various series. That's beyond the scope of this introduction, but it's something I want you to be aware of. So how do you conduct and segregate assets and liabilities in a protected series LLC? So the statute will lay out the rules for associating assets and liabilities with a particular protected series. There is the way to do it, obviously, is through books and records. Those books and records have to be segregated for each protected series. Now, that's not to say you can't have a master set of books and records using obviously electronic documentation, because electronic documentation is fine. But again, this is another word to the wise about not using it for mom and pop businesses who can barely get their tax return records together at the end of the year to file their LLC tax returns or their partnership tax, whatever. This is something that has to be monitored carefully. So as assets are accumulated and associated with a particular series, there has to be this association by record keeping of all assets and all liabilities, along with all associated members and managers of any protected series, and that has to be recorded. So the reason the record keeping is so important, and this goes back to the Uniform Law Commission's drafting sessions, where lawyers were worried that if you did not require serious record keeping, and the next slide will get into the record keeping, but if you did not require it, a bad actor could easily shift assets and liabilities among series internally by simply creating a little record. Today, let's say this truck and these pieces of equipment all belong to Series A. Series A starts to have some financial trouble. And so the party in charge decides, you know what, I better get my best assets out of Series A and move those assets into Series B. They would do that. So now a creditor of Series A goes to Series A and says, look, you borrowed $1 million from our bank. We want you to, you're defaulted. We're going to put a lien on your assets. And the Series A guy says, sure, here's what I got left. Here's my assets. And he gives you a list of assets that are worth, $1,000. All the good assets have been transferred. So to prevent that, the record keeping requirements become paramount. Slide. So the shields that are fundamental in protecting between the mothership and each of the protected series created by the mothership are these horizontal shields. And in order to maintain those shields, so that the assets of the entirety of the mothership, as well as all the protected series that are formed under the mothership, are not amalgamated and thrown into one lawsuit, is this record keeping that has to be maintained. So the record keeping is accomplished by assets and liabilities being associated in a record only if the protected series creates and maintains records that state the name of the protected series, describe the asset with sufficient specificity to permit a disinterested, reasonable individual. That's the standard. Describe the asset with sufficient specificity to permit a disinterested, reasonable individual to do three things. Identify the asset and distinguish it from any other asset of the protected series, any asset of the protected series LLC, the mothership, and any asset of any other protected series. That's one. Two, determine when and from what person the protected series acquired the asset, or how the asset otherwise became an asset of the protected series. And three, if the protected series acquired the asset from a series LLC or another protected series of the protected series LLC, you have to state how consideration was paid, who paid it, and the payee. This is the guts of the asset and liability segregation that is required under the Uniform Protected Series Act and all states that have adopted the Uniform Protected Series Act to prevent fraud perpetrated upon creditors or businesses that do business with a protected series. Because that's where you're going to have problems. It's not only lenders or judgment creditors who may have a beef and been injured by that protected series, but also other businesses that are doing business with a protected series. They want to know that the assets that they're relying on, that protected series says it has, and it's going to want to see a balance sheet saying what are the assets and liabilities of protected series A before I invest in that or before I do business with that series. So, fundamental. This slide I maybe should have put first, but it follows, in this case, the slide that says record keeping is critical because there are two types of shields in a protected series LLC. The first is what everybody knows as the vertical shield now that applies in an LLC, which means that the members and managers of an LLC are not responsible for the debts and obligation of the LLC simply by virtue of being a member or a manager in a Florida LLC. So that shield that protects members and managers from any debts and obligations of the LLC also applies to protected series LLCs. And it also applies to any protected series that are created by a protected series LLC. Additionally, we have these new horizontal shields. There are two aspects to the horizontal shields that the protected series have. The first is the non-liability rule that no associated member and no associated manager has any liability for the debts of the mothership or any other protected series. And there's the non-recourse aspect of the shield that says associated assets are protected from claims of creditors either of the mothership or creditors of the other protected series. And that's really important because obviously you all know that charging orders right now are judgment creditors' sole remedy in the case of multi-member LLCs in Florida. That same rule is going to apply to protected series that are formed from a protected series LLC in Florida. Unfortunately, we're stuck in Florida currently with the Olmstead rule. That's, for those of you who don't remember that or weren't around, in 2010, the Florida Supreme Court issued an opinion dealing with a regular old Florida LLC that a judgment creditor of a single member LLC, Florida LLC, could not is not limited to a charging order. And a charging order, for those of you who don't know what a charging order is simply an order that you get from the court once you get a judgment against an LLC that says this LLC owes money to this creditor, and any distributions that would have gone to the member, where the member is the party that owes the money for some reason, whether it's because they signed a guarantee on behalf of the LLC or because they somehow borrowed the money themselves and put it into the LLC, whatever the circumstance that created a debt by a member or manager of an LLC, but member is what we're focused on in Olmsted. If they had a charging order, they would simply never issue distributions to themselves because the creditors would be able to take those distributions instead of it actually flowing to the single member. I'm sorry, to any member. But what Olmsted said was, if it's a single member LLC, we don't think they should have this charging order protection that applies to multi-member LLCs. And that is still the law in Florida. The statute has not been changed to override that. And because we don't say that a charging order is the sole and exclusive remedy available to judgment creditors. And the reason we don't say that in Florida is because the banking lobby was very active in preventing that change from being made when the Florida Bar drafting committees tried to go back to the general rule applicable in most other states, which is that a charging order is the sole and exclusive remedy available to a judgment creditor. That same rule is going to apply to single member protected series. Okay, also that's advanced, but it's something that I think is important to point out. What happens when you want to dissolve a protected series? Now, remember what I said in the beginning. A protected series of a protected series LLC cannot exist except through the mothership, because the mothership is the legal entity. If the mothership is dissolved, all of the protected series formed under that mothership are also have to be dissolved. In fact, a dissolution of the mothership, protected series LLC, cannot be completed until each of any protected series that were formed under that mothership are also dissolved and wound up. So the winding up process is you have to obviously take care of the creditors, and the assets left over go to the members. And that wind up process in some cases takes years, most cases not, because we're dealing with small businesses. But we've had situations where I've been involved where it literally has taken years to complete the winding up process, in one case over 5 years, because of environmental liabilities and other liabilities that were in litigation. There was one case that went 10 years in dissolution. So that's important. You can, however, dissolve a protected series anytime. So if you created these 5, let's use my example of different types of real estate activities, and one of them is not working out and you want to dissolve it, you can do that. You can simply dissolve the series that is in trouble and needs to be wound up without it impacting the mothership or any of the other series. So that dissolution process for a protected series is the same dissolution process applicable to the mothership. You have to go through the same standards and hoops. End of the slideshow. So let me go back. I'm going to open this up to questions because I've got only 10 minutes left. And if there's no questions, I can talk some more. So let me open it up to questions and see if our moderator wants to advance any questions on behalf of someone who's got a question. No questions.
No
I'm
questions
gonna,
at this moment.
yeah. Did you say no questions so far?
We have no questions in the Q&A at this moment, but anyone that wanted to type in a question, they're more than welcome to do so right now.
Yeah. Um, let me mention one other thing. Since I used a real estate example, I should mention that there's some special considerations that are in the Florida Protected Series LLC Act that are not in the Uniform Protected Series Act, and it has to do with real estate. Uh, when we were drafting this legislation over the many years, the real property uh, and probate trust law section also commented. And through the real property section, there's a subgroup of title insurance companies that have special concerns. And so they wanted to have special rules built into the Florida Protected Series Act to address their concerns in writing title insurance for whether or not a protected series could hold real estate and what their remedies might be and how they are going to deal with um, filings and to make sure their filings are uh, accepted and filed appropriately in the offices when a real property, not only real property titles, but also any matters affecting real property are also filed. So we had to build in provisions that were specifically formulated to address the real estate concerns of the title insurance industry. And we reached a consensus uh, working with members of Reptile who were very helpful over a long period before we could get consensus. And that's something that I think is better for Florida. So now I'm finished unless somebody now has come up with a question.
So Louis, we have a few questions in the Q&A. I'm going to type them in there to see if you can see them. Give me a second.
Or you could just call them out, read it out.
Okay, so one of the question is, in light of bankruptcy risk and other similar risk, why would a financial larger business want to use a protected series LLC? And can you provide some hypothetical examples for better understanding?
Yeah.
And how is it taxed?
Well, first of all, no one, uh, the, I will give you, maybe I can answer this by saying that there is no definitive answer yet from the bankruptcy courts. And that's troubling. It's troubling for a number of people, but not enough to stop sophisticated investors from still using series. The example that I most recently ran into was within the last couple of months is a deal structure that had 32 Delaware series in the deal structure. And the 32 Delaware series uh, were all registered series because in Delaware, registered is the highest level of documentation. And they came to us with how can we, that was already done. All the money that was invested through this deal structure was allocated from investment funds, portfolio funds, uh, sovereign wealth funds, lots of different sources of very sophisticated capital, uh, with written operating agreements, of course, including for all of the various series. And the question came in, what can we do to at least build a defense to substantive consolidation of all of the entities if there is a series that has a problem and goes into bankruptcy? And the solution, albeit untested that has been utilized, including in this circumstance, was to create a blocker entity or entities, depending on the structure that might be required. That would be a bankruptcy remote entity utilizing an independent manager whose approval would have to be given in order to file for bankruptcy protection. And there's case law that indicates where that structure has been utilized, that if the independent manager who had to approve any kind of bankruptcy filing failed to give the required approval, and you had to build in a mechanism that said that independent manager had to approve any filing, as long as it was a truly independent manager, utilizing what's in the best interest of the LLC, refusing to give consent or approval, that the bankruptcy filing would be ineffective. Now, there was a twist into this most recent case that I'm talking about, which was the managers of the LLCs that were being put into bankruptcy never asked for the independent manager's approval. They never even told the independent manager, who was a lawyer, that they were filing. And it was only after the filing, when this was raised by creditors, that the bankruptcy court had to say, well, look, I don't need to look into whether or not it was appropriate to decline. I just had to say, you never even you didn't follow the operating agreement, which said you had to get the independent manager's approval before you could file. So that's not a satisfactory answer, in my view, to say, why should sophisticated businesses avoid them? Because they don't avoid them right now. Small businesses should definitely avoid them, and even sophisticated medium-sized businesses maybe should avoid them, because the bankruptcy issue is probably the most important issue. And again, I think in the one example I just gave you, the investments were all in fully functioning mortgages and fully functioning real estate associated with federal government intervention and federal government involvement. So these were really good investments if you were interested in investing in real estate with high values and with lots of sophisticated parties involved, including in the management of the various subsidiary or not subsidiary. Don't use the word subsidiary. I got to stop saying that. The various series within the chain of series. So it's still being done. First time I saw series being used was in 2010 and 11. That was in connection with Delaware series being used in other states, and lenders loaned to these series to buy the real estate and the businesses they were buying, and they have been doing it for a long time now, including, I'm talking major first-tier banks lending. So it's happening. Anything else? Another question? Yeah, one more minute, 2 minutes.
So, Louis, we have over 22 questions that came in around 12:50. In the interest of time, would you like to go over them? Would we be able to send maybe a follow-up email or provide our attendees? Or would you want to stay over and just answer a few of them that I've inserted in the chat for you?
Pick one or two. I unfortunately have commitments this afternoon starting at 2, and I need to shift gears to get to those.
Okay. I've
meeting.
included a few. I think like you can answer just the first one on the individual group chat. So let me go ahead and I can read that one for you.
Yeah.
How do you handle tax ID numbers and tax return filings?
Ah, uh, that's a good question. This is a tax section. So each series, protected series, should be subject to getting its own EIN and filing its own tax return. But what was the other aspect of it? But was there? Maybe I missed. Maybe that was the only thing that was being asked.
Mhm. Yep.
Okay. What's another question?
How are these entities recognized and registered federally?
I don't know how they're registered federally. I'm not sure what that means. Uh, it so I'm not aware of a federal, not that we have the CTA anymore being enforced. I mean, obviously, if the CTA was enforced, that might have been something I could talk about, but in terms of the registration requirements under the CTA, but that's not really going to ever be brought back to life, I don't think. So I'm
Okay.
not sure what federal registration, if it's something I'm missing. I'm not sure what the question means.
All right, that's fine. In the interest of time, would they be able to email you questions if they had any questions for some of our attendees today? Or would you have any future, presentations that you will be speaking at?
Uh, well, yeah, I've got future uh, presentations. I mean, if folks want to send it, recognizing I'm not going to look at it immediately and may not get to it until a weekend or something, they can send me questions.
Wonderful. Thank you so much for
All
speaking today. We truly appreciate the time that you took to speak to the tax section. And
right.
as a friendly reminder, it's 9480 CLE credit. And we have another CLE that's taking place on November 11th, the Mathematics of Estate and Tax Planning by Alan Gassman. We hope to see you all there then. Thank you and have a wonderful day. Thank you, Louis, once again.
Thank you, Andrea, and thanks for listening to the
Thank you.
attendees.
Goodbye.
Bye.